Kevin Haig.
Mr Speaker, I might begin, I think, by picking up exactly where Charles Chauvel's left off with this principle of urgency. This is a bill, sir, that has been standing on the order paper for some years. Originated with the Quality Regulation Review in 2007, sir, and it seems extraordinary to me that the Parliament is now in urgency to consider its remaining stages. There seems to me to be nothing about the bill that would justify urgency. There's nothing urgent about implementation of any of the detail of the bill. And so, sir, it fails to meet the test of urgency for this Parliament. So I just registered the Green Party's objection to the use of urgency to progress the bill on that point. The previous speakers on both the National and Labor sides of the House have spoken about the background to not only this bill but this type of bill. And the principle of examining existing legislation and regulation with a view to streamlining regulation, streamlining legislation, so that the interests of civil society and of business are advanced without cost to the public. And so I guess the Green Party would lend its support both to that principle, that where we can streamline legislation and regulation without a cost to the public, that we ought to do so, and that an omnibus bill is an appropriate way of advancing those changes to regulation that are identified in that way. So we support that principle. In the first reading debate on this bill, sir, there was considerable discussion about the principle that such a bill should be uncontroversial. And sir, I've heard the Minister, Honourable Chris Finlayson, in the House today again repeat that principle, that this bill should be about uncontroversial measures. And this is where the Green Party parts company with National and Labor on this bill. And so it raises an important constitutional point, because our Parliament has moved from the elected dictatorship of first past the post to an MMP environment. So the fact, sir, that National and Labor agree on the provisions of the bill does not make the bill uncontroversial. And so in the first reading debate, I outlined the Green Party's strenuous objections to several of the provisions in the bill. I raised some concerns about the changes to the HASNO Act, and in particular I spoke about the changes that were proposed to the Conservation Act and the Reserves Act, which seemed to me to be entirely objectionable and not to fit the tests of the bill. I'm going to speak some more about those. But, sir, for that reason, the Green Party will continue to oppose this bill. I want to talk some more about the principle on which this bill is based, because again I've heard the Minister, the Honourable Chris Finlayson, in the House again today repeat the statutory basis or the standing orders basis for this kind of bill, and he's again cited Standing Order 264A, which has now become 259A, and what that provides for is that an omnibus bill to amend more than one act can be introduced if the amendments deal with an interrelated topic that can be regarded as implementing a single broad policy, sir. And the government, in setting out this bill, claims that single broad policy is to improve the regulatory framework and reduce the compliance burden of business. And then it's gone to further elaborate on that broad objective, sir. So, for example, it says that the initiatives in the bill address regulatory duplications, gaps, administrative errors and inconsistencies between different pieces of legislation that collectively create unnecessary compliance costs and uncertainty for business. And the government says, in keeping with the scope of the review, the measures target poor implementation and administration of various regulatory frameworks. Government then goes on in the original explanatory note to talk about how these many small gains can make a larger overall impact in removing barriers to economic growth. So I'm not going to debate the desirability of economic growth, although that is a live debate in this House, sir. And again uses the sort of rhetoric of transformation. So government claims that this is a broad suite of measures to address all of those goals, that they're uncontroversial, and for that reason they meet the test that's set out in 264A, sir. Now, the Green Party is strongly opposed to the changes in the Conservation Act and the Reserves Act. That means that the bill is not uncontroversial. I note the government's intent to split the bill in the Committee of the Whole House stage into separate bills, but at this stage in the House, sir, in the second reading debate, the bill still fits under the umbrella of Standing Order now 259A, sir. And I'm going to submit to you, sir, at the conclusion of this speech, that in fact the bill does not fit the test required by that standing order and should not proceed. The concerns that I talk about in this debate, sir, are ones that I did raise in the first reading, and it's disappointing to me, sir, that the Commerce Committee did not consider the issues that I raised at that point, because the problem that I'm raising today, sir, could have been dealt with at that time. It could have been dealt with by the Select Committee. And in my first reading speech, I offered the Green Party's cooperation to all sides of the House, in fact, to actually deal with those problems. And it's a disappointment to me that offer was not taken up. I want to, in particular, talk about the changes to the Conservation Act and the Reserves Act, because they do two things. They raise the maximum period of a concession from the current maximum of 5 years to a maximum of 10 years. And so they also provide for discretion not to publicly notify such concessions. And what I'm saying, sir, is that neither of those measures, in fact, meets any of the objectives that are set out in the explanatory note to the bill or that are required by the purpose of that standing order, sir. While most of the provisions in the bill, in fact, do meet the test, they do meet the test of being regarded as implementing a single broad policy, and in this case, sir, the broad policy of improving the regulatory framework and reducing compliance burden on business, neither of those, in fact, does. Neither of those is about that at all. In fact, they're about other measures which government has chosen to put into this omnibus bill, and therefore they fail to meet the test, and the bill should be ruled out on that basis, sir. The increase in concessions, for example, sir, the period for a concession moving from 5 years to 10 years doesn't improve the regulatory framework at all, and sure, it does probably reduce the compliance costs for the particular business that has that concession, but it actually increases costs and actually creates barriers to good business practice for every other business. And it actually creates problems for the New Zealand public, sir, because the New Zealand public has an interest in the conservation estate that is not well served by that increase in concession period. And I'm going to talk about that in the committee stage, sir. So look, I'll wind up the speech at that point, but if I can immediately, sir, take a point of order.
Point of order, Kevin Haig.
Thank you, Mr. Speaker. My point of order is this, sir, that this bill, the Regulatory Improvement Bill, does